Welcome to the Live Big podcast, where real estate expert Nick Paynes shows you that everyone can build wealth through real estate investing. Nick and his featured guests will give you the tools, resources, and expert information you need to leverage real estate into a wealth-building strategy, so you can stop worrying about your 9-to-5 and start to live big. Here's Nick with today's episode.
Welcome back, everybody, to another episode of the Live Big podcast. For those of you watching on YouTube, I am in my home office today, and so I've got this nice virtual background. This is the offices of one of my listings, actually, the last couple months. So anyway, for those of you listening, you don't get to see the beautiful office that I get to sit in front of, but we got some great information for you today. It's going to be I'm going to try to make it as interesting as possible, but what I want to review today is the 2023 Colorado residential leasing changes. So obviously this is Colorado specific for those of you that are listening in Colorado. If you're not in Colorado, I would encourage you to make sure that your leases are up to date, that all of your information between your landlord and tenant relationship law is up to date in your leases. We had a lot of changes here in Colorado, and so I'm going to review those today. Full disclaimer, I am not an attorney. I don't claim to be an attorney. I recommend that you reach out and have a new lease agreement written up by a local attorney and somebody that can make sure all the proper provisions are put in place. So I want to get to some of the major changes because there were some big ones. So many of these laws were passed June 6th of 2023. And now they are put into place and are effective as of August 7th, which is 3 days ago from the time I'm doing this podcast, about a week and a half from the time you're hearing this podcast. So I'm going to explain some of these things, and I don't have a lot of the answers yet of questions that you may have as far as, well, what happens if I have an existing lease? What happens do these provisions apply to an existing lease? Do I have to change my lease if I'm mid-lease, that kind of thing? Again, these are going to be questions for attorneys. I just want to make people aware of what's coming up, and also make people aware, if you are renewing a lease, these are the things that do have to be in your new lease. So once again, not an attorney, but please reach out to one to go through these. You can look up the new laws. There are a bunch of attorney websites. You can also go to the Colorado General Assembly website, and you can read about the new acts. So these laws are usually labeled. Like, for example, our first new law is SB 23-206. And so once you go in, you can read about the protections or anything that's in there. And then you can also see the status of the bill, which you'll generally see is introduced, passed, and has become law. So these are things that have been introduced usually mostly here in 2023 and has gone through the revision process and was signed into law on June 6th by Governor Polis. So a lot of these also you can go in, and I would recommend, if you want to learn more about it, you can learn the actual bill text. So you can go in and see the actual bill itself, when it was signed, who signed it, and read more about each particular provision. So a couple of things. One of the big ones, and this affects not only our real estate contracts, our rental contracts, but it affects our real estate transactions as well, is that I shouldn't say the new big thing, but I'm going to call it the new big thing. It's radon disclosure here in Colorado. So radon is the new lead-based paint here in Colorado. So if a property was built prior to 1978, In Colorado, we need a lead-based paint disclosure, and I actually think that's federal. So I think that any property built prior to 1978 throughout the United States requires a lead-based paint disclosure, with disclosure from the seller as to whether or not they know about the presence of lead-based paints, or have ever had any tests done or remediation done. We now have that same type of disclosure or similar disclosure with radon. And so with radon, there's no dates. It is literally, if you own a property here in Colorado, all residential landlords and, well, residential landlords, property managers, and sellers of property need to start providing a Colorado radon disclosure form, which talks about the same thing. Have we ever tested for radon? Have we ever installed any type of radon mitigation system? Do we know about the presence of radon? And so, again, this is something that is happening throughout the state, through all residential real estate transactions, and up to and including your rentals with your landlords and your property managers. So, using a property manager, make sure that they understand. I would call and check with your property manager if you've got a new lease coming up, to make sure, hey, do you guys have the new radon, Colorado radon disclosure that you're supplying to our tenants? So a little bit about the radon information for residential property. First of all, if you don't know much about radon, I encourage you to go look at read a little bit about the effects of radon. There's EPA pamphlets. There's information from the Colorado Real Estate Commission, but really the EPA pamphlets. Basically, radon is a naturally occurring radioactive gas that's found in soil and groundwater, and it's recognized by WHO, or the World Health Organization, as a carcinogenic toxin, and it's the leading cause of lung cancer outside of smoking. Okay, so kind of as a result, here in Colorado, anytime we do a residential real estate transaction, we have to make disclosures about known existence of radon on the property. So the landlords, as far as, again, purchasing, that's something that we're taking into account right now. Landlords and property managers of Colorado real estate now have to disclose and provide the following to potential purchasers or tenants. Okay, so they have to include a warning statement. It's included in the statute. So if you have your own lease, if you go in the statute, okay, there's language in there. It's bolded, that you can use and put in your lease, that talks about the dangers of radon and the recommendation to conduct testing. All right. So the second thing you have to do is any knowledge that the owner already has about radon concentrations in the house. So first of all, whether any radon tests have been performed on the property, any current or the most current records and reports pertaining to radon on the property, a description of any radon detected, mitigated, or any remediation that's been performed, any information regarding any radon mitigation system on the property, and a copy of the most recent brochure that was published by the Colorado Department of Public Health and Environment that provides advice about radon in real estate transactions. Okay, so those are the things that have to be supplied to your tenant with your residential lease agreement. So there's nothing here that says you have to test for it. There's nothing here that says you have to mitigate for it. So if you have no knowledge of radon on the property, all you do is that you give them the warning statement and let them know that you have no knowledge of radon on the property. Okay, but what it does is it encourages the tenant and recommends that they conduct testing. Okay, so if we fail to provide this information, or the tenant goes and finds that we have high radon levels, okay, then the tenant may actually void their lease and they can vacate the premises in accordance with Colorado's warranty and habitability laws. All right, so it is really important that we make sure that these disclosures and requirements are there, because they can technically void their lease with this. All right. So that's the first big one. So make sure you have a radon disclosure form. It's extremely important. Again, you can get many of these forms from a law office. You can actually look up the bill itself so that you can pull the text from there and make sure it's in your future leases. Again, not a lawyer, so don't, not really having advice here, but I would think the warning statement that you could pull from the bill itself, put into an additional provision section of the lease, as well as, disclosing any knowledge you have. So if you have no knowledge, landlord has no knowledge of any radon on the property, there's never been a test performed, et cetera, et cetera. You're going to have likely something like that. But again, contact a real estate attorney to make sure you have everything in line the way you need it. All right. So that's the big one. And that, like I said, that kind of overflows into the residential real estate sale side as well. So the next piece is prohibited provisions in rental agreements. So there are some things that we used to have or that we used to be allowed to have in residential rental agreements that we can no longer have. So the things that we can no longer have, there's a handful of them. I'm going to go over the majority of them here. But one of them is a one-way fee shifting clause that awards attorney fees to and court fees to only one party. So if you do have a fee shifting clause in there, and something that awards attorney fees, it has to award the attorney fees to the prevailing party, and it has to include the language that says following determination by the court that the party prevailed and that the fee is reasonable. Okay, so it used to there. I don't know why that has to go in there. I thought that when I read it, I thought, well, that's kind of assumed, but it has to be part of your lease agreement now. So you can't waive any of these certain things. You can't waive a jury trial. You can't waive the ability to pursue the actual clause is to the ability to pursue, bring, join, litigate, or support any kind of joint, class, or collective claim or action. You cannot waive the implied covenant of good faith or fair dealing, and you cannot waive the implied covenant of quiet enjoyment. Okay, that's a fairly standard piece of the quiet enjoyment piece of a lease that basically says, like, you can't just go disturb your tenant whenever you want. They have the ability to live in the home and have quiet enjoyment in the property. So an interesting one here is you can no longer put a provision in the lease that allows you to affix any fee or damages or a penalty for a tenant's failure to provide notice of non-renewal of a rental agreement. Okay, prior to the end of a rental agreement. So let's say, for example, you have a lease that ends September 30th, and you have in your lease that it requires 60 days notice for renewing. And let's say you don't stay on the ball and you don't ask the tenant if they're renewing, and September 15th rolls around and you say, hey, are you renewing your lease? I need to get this figured out. And they go, no, we're not renewing. And you go, well, you were supposed to give me 60 days notice to let me know you weren't renewing so I could start marketing the property. No, that's not on them. That's on that would be on you as a landlord. You cannot affix any fees or damages. They're just assuming their lease is up. That's on you to make sure that you understand, 60 days prior that they're either renewing or non-renewing. And even if they say, I'm not sure yet, I would let them know, well, I'm going to start marketing the property, because if you decide to leave, not renew 30 days from now, I don't want to be behind the 8 ball. Okay. So, you cannot, so other than your monthly payments, your essentially your rent for occupancy of the premises, any provision that you have that characterizes an amount or a fee as rent, which could lead to remedies such as an eviction or the event of non-payment, you can no longer have that. So basically, if you have like an additional fee that you're counting as rent, I don't know what an example of this would be actually. What comes to mind is, if you charge somebody a $50 per month fee for yard maintenance, and they didn't pay it, that the way it looks to me is like that is not something that you could lead to an eviction. If they don't pay that, it can't lead to an eviction. Now, I suppose if they're not keeping up the yard because of that, that could potentially lead to an eviction because if you have some type of provision regarding the upkeep of the premises, that would really be important. Okay. So, um, a provision that requires, so this is again something that can no longer be in a lease, a provision that requires a tenant to pay a markup for a service for which the landlord is billed by a third party. So, let's say the landlord gets billed $100 a month for yard services. You cannot bill the tenant $150 a month for that. There is an exception if you have a written rental agreement with that person or with that tenant that requires the tenant to either pay a markup fee in an amount that does not exceed 2%. So if it's $100, you could charge $102, or an amount that does not exceed a total of $10 per month, but it can't be both. All right. But that has to be written into the lease. So there's a little bit of clarity issues on this particular one, on this particular thing, but it's basically some things that people were putting into provisions of the lease before that you can no longer do. So those are all prohibited provisions. All right. The next one is pet and animal ownership and housing. So there's a lot of discussion about this that we've. I think I don't remember if we've talked about this in a previous episode, but we've talked before, or at least I've talked before, about the presence of things like ESA animals, so emotional support animals, and how emotional support animals are basically you cannot charge fees for emotional support animals. So the problem is that for about $100 you can go online and get some doctor in some other state or maybe even some other country to issue you something that says you have an emotional support animal. And so I have a couple arguments to that, or arguments against that, which is I feel like I could make an argument that all pets are emotional support animals. For those of you who own pets, I think it's pretty easy to say that, hey, if you're feeling stressed or you feel anger or if you feel sad, does it help you to sit down and spend time with your dog or your cat or whatever it may be? I would think that the answer is yes. I mean, the reality is that's why we have pets. Pets are emotionally supportive to our lives, and that's why we have them. And so I think it could be argued that all animals are emotional support animals. However, the problem is we have people taking advantage of the fact that it's easy to get an ESA certification or classification for their pet, and taking advantage of that to avoid things like airline fees and pet rent fees and things like that. So, unfortunately, what I think is going to happen is it's going to actually end up hurting people because there's going to be landlords out there that just say no pets. Now, an emotional support animal is still considered a pet. An animal that is and the verbiage is escaping me, but an animal that is supportive of like a disability, like a somebody who is blind, for example, if they have a dog, a service dog, that's not considered a pet. In fact, by law, it's essentially not considered an animal. It's an extension of the person. And so when you're renting and you say no pets, a service animal is not a pet. An emotional support animal is. So an emotional support animal could be denied for the fact that it's an emotional support animal if you have a no pet clause. Okay. However, if you have a pet clause that says, yes, we allow pets, but it's $50 per month, you cannot charge that to an ESA animal. Okay, so there's basically like three different distinctions at this point of an animal. The first one is a service animal. Okay, and that is not an animal, it's an extension of the human being. It's no different than like a wheelchair or like crutches or something that's like a permanent fixture to a disabled person. Okay, so just like you couldn't deny someone that to live in your home because they're in a wheelchair, you cannot deny somebody to live in the home because they have a service dog, because that service dog is essentially like a wheelchair to that disabled person. Then you have the emotional support animal, which is still considered an animal, but you are not allowed to charge fees. You can't charge deposits, and you can't charge monthly pet fees. And then you have just a straight up pet. Those you can charge fees for, you can charge deposits for. So we kind of have these like three different levels of animals that live with us in our rental properties. All right. So in this case, the pet animal ownership in housing, essentially what this does is the new provisions that we have here limits the amount of security deposit that a landlord can demand, and as a condition of permitting that the tenant's pet reside on the property. So in Colorado now, they've limited it to $300. Now, one of the things I don't know, I'm still researching and trying to figure this stuff out because these are very new laws. Again, these went into effect 3 days ago. Is if that is $300 total, or if that's $300 per pet. The second thing is we used to be able to do non-refundable pet deposits. In this case, we can no longer do non-refundable pet deposits. So the additional pet deposit has to be refundable to the tenant. Now, obviously, if you have damage that was caused by the pet, that can come out of that. Okay. And so we hold an additional deposit in case there's damage done by the dog, but we can no longer just straight up do like hey, you get a non-refundable pet deposit. So again, I do not know if this applies to your current lease agreements, and I don't know how it applies to multiple pets. So maybe I'll get some answers on that and do another podcast to clarify. But again, if this is something that affects you and your rental properties, I strongly suggest that you research this and find this information out for yourself. The second thing is that the additional rent that you charge, or what we would call pet rent, on that property can no longer exceed the greater of either $35 per month or 1.5% of the monthly rent amount. Okay. So if you're renting a property for $2,000 per month, your pet rent, okay, can only be 1.5% of that. Okay. So that would be $30 per month. If you're renting for $3,000, it could be $45 per month. Okay. So it's the greater of. So I apologize. I just said if it was $2,000 per month, it's the greater of. So you can do $35 per month. Okay. So, so anyway, I know for me that has to change some of my provisions that I have in my rental agreements. I was charging usually right around $50 a month for pet rent. Okay. So a good law that we have, I suppose this is all these laws so far have been fairly tenant friendly and not really landlord friendly. One of the good laws here, and I think this is good for both the tenant and the landlord, but this same act, the Pet Animal Ownership and Housing Act, also prohibits insurance companies from refusing to issue, canceling, refusing to renew, or increasing premiums on a homeowner's insurance policy, or like a fire insurance policy based on the breed or the mixture of breeds of the dog that is kept at the dwelling. Okay. So we used to have issues as landlords renting to people who maybe owned like a pit bull or owned a Rottweiler or a Doberman or a breed that was previously deemed to be, a violent, I shouldn't say violent, but like a dangerous dog. So the only exception to that provision is that if a particular dog that's kept on the property is known to be dangerous or has been declared to be dangerous, okay, then it can be. So if you've got a dog that you have multiple complaints against it or something like that, like attacking people, that can do it, but it has to be a particular dog, not a particular breed. All right. So really good information there. A lot of you have leases that include pets and pet rent. So make sure moving forward when you renew your lease that you know that these provisions are in place. All right, a couple more. Portable screening reports for residential leases. So landlords are now required to accept what's called a portable screening report as part of the application process. And in that case, if the tenant has a portable tenant screening report, the landlord may not charge that tenant an application fee. So a portable tenant screening report usually includes information about the applicant from a consumer reporting agency. It's going to have their name, their contact information, verification of employment and income, their last known address, rental, credit, criminal background histories. So everything that we usually get anyway when we do an application, they now have these portable screening reports that these prospective tenants can go get, and they can use for each individual property that they want to apply for. Okay, there are some restrictions upon it, so landlords can have some requirements. So here's some of the requirements that they can have. First of all, it has to have been completed within the last 30 days. Okay, so they can't hand you a screening report that was done 6 months ago. They could have lost their job since then. Their income could have changed. That type of stuff. Okay. It has to be made directly available to the landlord, through the consumer reporting agency or by a third party website, in compliance with applicable consumer reporting laws. So a good example of something like this is Zillow. If you accept Zillow applications, basically what happens is the tenant applies on Zillow, and fills out their application form specifically on Zillow, and then they can use that application to push over to multiple properties that are on Zillow, so that they don't have to keep paying application fees. So this is basically kind of what this is. So it has to be provided to the landlord at no cost. They can't ask you to pay for something in order to get it. And they have to make a statement that basically says from the prospective tenant that there has not been any material change in the information provided in the report. Okay. So there's a couple of things. There's some exemptions that are involved here, but I'd be careful with these because I feel like there's a lot of gray area here. But if you as a landlord, if you don't accept more than one application fee at a time for a dwelling or a unit, then you basically have this exception here, right? So you can accept it if you're not taking multiple applications. The idea here is there were people taking 10, 12 applications and keeping all the application fees and using it as like an income generating thing just to accept applications. I'm one of the people that I only accept one application at a time. So I let them apply. If it's not good, I move on to the next person. But basically, I'm having a conversation with that prospective tenant. I think they have great character. I say, hey, as long as everything looks good on the application, I think you would be a good fit. Why don't you go ahead and apply? And if everything looks good, I'll offer you the property. Okay. So the other thing is, if as a tenant, or I'm sorry, as a landlord, you are taking on multiple applications at the same time, as long as you're refunding the application fee to each prospective tenant within 20 calendar days, then you can do that. Okay. So again, there's some things there that I would just say, either accept one application at a time or just be really careful with the way that you're accepting application fees. So, all right. This one's really interesting to me. This one definitely affects me in the way that I rent my properties, and directly kind of negates some of the information that I have in my investment experience book that you guys can download from my website that talks about some of the things that I look for. Basically teaches you how to manage your own property. And in it talks about some of the things I look for when I'm looking for a prospective tenant. It's going to have to change it's going to have to, this particular law changes some of the things I look for. So first of all, if landlords are using rental or credit history when considering applicants, which is generally what we do, the act that was passed limits the landlord's ability to consider or inquire about certain aspects of the applicant's income. So you got to be really careful about, again, there's some gray area here. Like what does that mean? Like what aspects? There's certain aspects. What can't I inquire about? Okay, but landlords who are renting to prospective applicants who are seeking to rent without assistance of a housing subsidy shall not require, this is what goes directly against what I suggest, shall not require that the applicant's annual income exceeds 200% of the annual rent amount. Okay, so let me say that again. You cannot exclude okay, or require that your tenant or your prospective tenant make more than 200% of the annual rent amount. So in my book, I recommend that people make 3 times the rent amount, whether it be monthly or annually, it doesn't matter. It's the same. But I always recommend, like, if rent is $2,000 per month, I think they should make $6,000 per month to qualify. You can no longer do that. Okay. Income and annual income or monthly income, whatever, as long as it exceeds 200% of the annual rent amount, you cannot basically discriminate against that. Okay. So, pretty interesting for that piece. So it also says here that the act also limits the security deposit that can be required of residential tenants to no more than 2 monthly rent payments under the lease. That's kind of nice, actually. It still leaves us the ability to take bigger deposits, which I might do in the event that we have a 200% of annual rent amount. I might take a bigger deposit. So I only usually take 1 month's rent for deposit, but in this case, income, this income restriction brings it down to. I think there's an issue with this. If I were to interject an opinion here, I think what's going to happen by doing this is we're just going to cause more rent burden. People spending 50% of their income on their rent, and we're talking about like gross income. I mean, if you're trying to rent a place for $2,000 per month and you only make $4,000 per month gross, I mean, by the time you're done with taxes, you got $3,200 left in the bank. You're gonna have $1,200 after you pay rent to pay for your entire monthly expenses, your phone, your insurance, your gas, your whatever, your car payment. So that makes it really tough. But anyway, you can no longer limit that. So keep that in mind. So those are the major provisions, again, that have changed here in Colorado. Again, extremely important that you understand what these provisions are and how they affect you and your lease, and recommend speaking with some type of residential real estate attorney to get a proper lease drawn up. So if you have any questions, please feel free to reach out. I can potentially point you in the right direction to the people that can help you out and help you put this together. I'm still working on getting mine put together through an attorney for all these new provisions, but it's really interesting that these come out. A lot of this came out kind of mid-year. For the real estate side, for the real estate sales side, it's very uncommon that we see contractual changes. First of all, the Colorado Real Estate Commission kind of has like a promise to real estate brokers that says, hey, we'll only change the Colorado real estate contract to buy and sell at least once every 3 years. So it's on a 3-year cycle. So any changes that they're looking to make, they just put it on the docket for the next change year. We had our residential real estate contract changed a year and a half ago. And so, but because this radon provision has now come in, which is obviously extremely important, we're making a contract change. First of all, not only outside of the 3-year window that we're kind of promised, but we're making it mid-year. So new contracts are coming out this week as we speak for residential real estate purchase transactions. So obviously a very important provision in the eyes of the Colorado government and Jared Polis and everybody who put these laws together. So anyway, I hope this was helpful. I don't want it to deter anybody from getting into real estate. There's still great opportunity, even though we see a little bit more restrictive policy on our leases. There's still plenty of good people to rent to, and still plenty of opportunity. And we are seeing some rent growth here just because of our current rate pressure that we're seeing. So that's it for today. I hope that was informational. Hope you didn't fall asleep. It wasn't too boring. I think it's just necessary information that we need to cover at this point in time. This podcast probably will not age well if you're listening to this after 2023. These provisions will already be in place, but maybe it will. Maybe you're still doing lease agreements in 2024, and you listen to this and realize that your lease agreement is completely out of date. So anyway, hope everybody has a great rest of the day, week, month, and remember, go out, live big.
Thanks for joining us for this episode of the Live Big podcast. For even more real estate and investment resources, go to blackyetigroup.com/resources and download Nick's complete guide to running your own rental properties. Tune back in next week for another episode, and until then, live big.
Live Big does not provide investment, legal, or tax advice, and nothing herein should be construed as being financial, legal, tax, or other advice. Live Big does not represent that any securities or services discussed are suitable for any investor. No investment or other decision should be made solely based on the contents or information found on the website or podcast. When making a decision about your investments, you should seek the advice of a professional financial advisor or qualified expert.